May it please the Court, my name is Seth Skiles. The District Court erred in its analysis of the two copyright issues in this case. First, the District Court erred in not finding that my client Big Time was actually the owner of Virtual's ZenQuest landscape under a valid work-for-hire agreement executed just prior to Virtual's release of the ZenQuest landscape. Second, the District Court erred in finding that Big Time was an infringer of Virtual's ZenQuest landscape.
Well, was he really an employee of the Big Time?
No, Your Honor.
On this committee?
Excuse me. No, Your Honor.
No, he wasn't.
No, Your Honor.
And did they specifically hire him for this project?
Your Honor, Big Time asserts that the employment, that the work-for-hire contract that Mr. Walker signed assigned the Virtual ZenQuest landscape under prong 2 of the work-for-hire statute, which states that when an entity commissioning a work and the artist sign an agreement that creates a work-for-hire, then the ownership vests in the entity that commissions the work. And here, that is exactly what has occurred. Mr. Walker and Big Time executed an agreement which assigns or creates initial ownership with Big Time because it states that all ideas, programs, as in software programs, sketches, and other things created with Mr. Walker's improvement or Mr. Walker's work on the committee vests in Big Time, and that's exactly what's happened here. So,
wasn't the development at issue created first after he stopped working on the committee?
The record is unclear as to when the spark of the concept actually came about. We do know that he
left in November of 2004. The work he started, I think, was in December when he came up with the idea, and in fact that was the record as far as I can suggest the first concept he had of search dissatisfaction occurred in December. Am I correct?
Your Honor is correct, exactly right. However,
so then the only evidence of record of when he conceived this copyrightable subject matter is after he was taken off of that committee.
Your Honor is correct. However, the agreement extends beyond his time on the committee because it also captures ideas that relate to the committee, and he first expressed this idea in a chat room, in fact Big Time's The Game chat room, as not something which was going to be its own game, and this is a key fact. He first expressed it as one more landscape for my client Big Time's The Game, which suggests that in fact he was hired to create new landscapes for the game, and then that's exactly what he did, was suggest a new landscape for the game. And then he decided, instead of giving it to Big Time, as he should have under the contract, that he would go off and take it and make it his own creation. And Big Time merely asks that this court respect the terms of the contract, which are clear in forcing Mr. Walker to give back that which he really created, not maybe at a committee meeting, but which is clearly related to the committee's purpose, which was to create new landscapes for the game, and that's exactly what he did, was create a new landscape for the game.
And then the chat room discussions, according to the record as I see it, 21, suggests that Al didn't talk about it until December 2004, and that was when he was off the committee. And it isn't clear from the record, if I'm incorrect in my understanding, he was still employed he was employed as a consultant, was he not?
That's correct, Your Honor.
And his consultancy ended in November 2004.
Yes, Your Honor, his actual attendance at the committee ended, but
Are you suggesting that this contract he signed in November 2004 had post-employment effect?
Yes, Your Honor, because for two reasons. First, the language of the contract is broad. It doesn't say that he needs to suggest something at a committee meeting in order for Big Time to own it. It merely needs to relate to what the committee was doing. And what the committee was doing was creating new landscapes, and that's exactly what he did.
if there's an ambiguity in that contract, shouldn't we construe that ambiguity against the drafter of the contract, which in this case is Big Time?
Your Honor, Big Time submits that there is not an ambiguity, and in fact that contract is clear in stating that Big Time owns his work that relates to his work on the committee, which was new landscape creation. And that's exactly what he did. And we're not suggesting that the contract lasts out into infinity. In fact,
why if we take your concept or argument at face value, I mean, it seems to me that you're arguing this is an obligation in perpetuity.
No, Your Honor, there's...
And at what point does he no longer have an obligation to them? You say it was 1 month later, if he conceives it a month after he leaves them, he has an obligation. Does he have it? Did he have to wait a year? Is it 2 years? I mean, where's the deadline? And if there is an ambiguity on that issue, then this is, as my brother says, an ambiguity that should be construed against Big Time.
Your Honor, for his services with respect to the contract, Mr. Walker was paid for 1 year, thus suggesting that the proper term for the contract is 1 year. Generally, a contract should last as long as one is being paid for the services in the contract. This is a reasonable term for this contract.
Where in the record does it say 1 year? I mean, I was looking at 18, 19, 20.
The record states, and I'll have the exact paragraph number for you in just a minute.
18, Al received free dues for a year and 1 free character. That's what you consider the consideration for this agreement?
Well, that's correct.
That's the compensation. He's getting free dues. It doesn't say he's obligated for a year.
No.
Are you suggesting that by accepting the free year, he has to be obligated to them for that 1 year?
Yes, Your Honor, that's our position. Moving to the copyright issue, there are 2 key dispositive issues in the district court's erroneous finding that Big Time committed copyright issue. First, what is the correct standard by which we are to judge these 2 works? And second, does the amount of similarity between these 2 works rise up to meet that standard sufficient to find copyright infringement? In the video game and computer screen realm of copyright law, there are 2 standards by which works are judged. There is the substantial similarity standard, and then there is the much higher virtual identity standard. Virtual identity is applied between 2 works when the copyrighted work is subject to a limiting doctrine because the copyrighted work itself is of only limited protectability. Video game cases uniformly have held that sins affair is a very relevant limiting doctrine when considering a copyrighted video game work. Sins affair states that ideas or elements that are typical or standard in the use of a given theme or topic are given only limited copyright protection.
So is there Supreme Court law on what is an infringement in a copyright?
Yes, Your Honor, most recently being Feist v. Rural Publications Service, I believe. However, that dealt with a sort of maybe analogous but not exactly on-point issue. So the copyright realm, the video game cases have all occurred at the regional appellate circuit level.
Well, this is kind of a design. Why shouldn't we apply, say, the design patent infringement test that the Supreme Court has applied in Gorham versus White?
Your Honor, I'm not aware of that test. What I am aware of is that these video game cases have been dealt...
It basically says that if an ordinary observer would believe that the 2 were so similar that he would mistake one for the other